Good morning. You may be seated. We are here on our case number 1 CACV 170413FC, in re the marriage of BARRON versus BARRON. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you would please give us your name and the name of your client when you approach the podium. We have studied the briefs and reviewed the record and the evidence before the Superior Court at the time it ruled. We've also discussed the case in our conference this morning. So with that, you may proceed.
Good morning, Your Honor. Your Honors. My name is Alan Cook, and I am representing the appellant, Major Paul Barron, who's an officer serving with the United States Marine Corps. Counsel, good morning. I do want to reserve some time, hopefully at least 5 minutes. I do think, Your Honors, that the reply brief addresses succinctly, I think, most of the disputes that involve in this case. I note in the reply brief that it concerns me that appellee chose to include the transcript of temporary orders hearing on the appellate record, even though it was not part of the trial record in this case. The court didn't have that transcript or acknowledge that transcript, and no reference was made to it at the trial of the matter. And I think
it a different judge?
It was the same judge, Your Honor. But that doesn't mean that they remember what happened or that they go back and look at a transcript or recording. There's nothing in the record to indicate that Judge Roof went back and looked at the transcript of that hearing.
Does he have to?
I think, Your Honor, if he's going to rely on it, I think, yes. I don't think the court should assume that he remembers something that happened at a hearing that happened several months before. But even...
we wouldn't assume that he simply disregarded all of that evidence that was presented, would we?
I've had very few cases, Your Honor, where judges with such heavy caseloads, particularly in family court, can remember what testimony was given at some time previously. He knows what the temporary orders were. We agree with that. And the temporary orders provided for almost equal parenting time. We know that with respect to his decision, with respect to his final orders on parenting time, he made a finding, essentially, that father was not reasonable for relying on stipulated temporary orders. And that even though father was willing to swap parenting time and mother had offered to do so initially, that he's the only person who's unreasonable for not doing it, even though, I mean, I fail to see how that could be reasonable. He made assumptions that children weren't doing well, and yet the only third-party records with respect to any of that is the school record, which show that the children were doing better at time of trial than they had been doing at the time temporary orders were entered. If you look at their deportment issues, and I've given you those exhibits in the appendix to the opening brief. So the reply brief lists all the different areas, again, that where the court's findings are not supported by the record. And I understand it's very, the court generally doesn't want to put itself in the position of the trial judge or the finder of fact. But here we have a case where he's made assumptions about where father will or won't be that aren't supported by the record, for example. Just because father's in the Marine Corps doesn't necessarily mean that he's not going to be able to care for his children. It doesn't mean he's going anywhere anytime soon. Both parties testify they want to relocate to San Diego. He's not the only one that said that. Mother said that too. But nobody stated any intention to do so. And I think if you look at the totality, and particularly when he says the girls should be with their mothers, I mean, which I think is contrary to statute. We do have a provision in 25-411, for example, about what happens if somebody gets deployed or can't look after the children. So there's a procedure for dealing with things like that. And so I think if you look at the court's findings and you look for the evidence to support them, that there are so many findings that aren't supported by the evidence that I don't think the court has a choice but to suggest that the court look at this and change its view with respect to certain things, particularly with respect to the sex issue. And
I've got some questions
yes.
about military retirement pay. I didn't want you to.
Well, I was going to get to that. That was my client's. That's the second most important
Okay.
thing he raised. Children was the most important. He raised that first, and let's talk about military retired pay. I'm happy to.
I've got a couple of real detailed questions.
Sure.
Small. Okay. When in a case like this, when the court is going to enter a quadro, presumably to divide military retirement pay, is the setting aside the issue of the specific order here, which was that husband needs to indemnify wife to the extent that he doesn't take retirement at 20 years, is the non-military spouse's share of retirement always calculated based on 20 years? Or if the military spouse continues to work past 20 years, does that adjust the formula?
Well, it's interesting that you asked that. Let me start by saying this. We have CELCH, which deals with the public safety pension, which is an Arizona pension, and I think the Arizona Supreme Court is the ultimate legal authority in the country with respect to that issue. Husband's in the military, and he was in the military when wife married him, and so she knew that he was a career soldier. And the federal statute, 1408, 410 U.S.C. 1408, says that the court can't order people to retire or things like that. And we have an order here that's kind of tantamount to that, telling him he has to start paying at 20. Although we disagree that the dates the courts use are exactly correct. But that's a difference of a percent or something. That's not de minimis. It also says that what she gets is a percentage of his base pay at the time of the decree, even though technically in Arizona we now have a statute that says the marital community is terminated upon service. But put that aside. So look at the date of decree. I confess I wasn't aware of that change in the statute at the time we were in court, but in going back to the statute I saw the change and mentioned it in the brief. And then the question that you pose is a good one, because basically what you're talking about is what the rule was before CELCH, which was whenever the husband retires, you base it, the numerator is the number of months of marriage or percentage of marriage, and the denominator is the number of months in the plan. And do I think, it's a good question, do I think, and I would tell you in all candor, I mean my client may not like me saying this, under the old rule what happened was they got their retirement benefit based upon the pay at the date of retirement. And so it wasn't necessarily true that the spouse, the alternate payee, got less at that time than they would have gotten at 20 years. Because sometimes people get big pay raises.
Yeah, is it a wash?
Somebody becomes a chief of police, and now instead of his retirement being based on 80 or 100,000 a year, it's based on 200. And so it can be huge. And under the old rule, if somebody stays past 20, generally speaking, that means they're on track to be a general or something, and the pay for a general is a lot more than it is for a major. And so it could actually be a bigger benefit. And so would it balance out over time? I don't know. I think that depends on the facts of the individual case. But to me, if the court had made this order, I don't think we'd be here dealing with this issue, that at such time as husband retires, he pays wife 29% or whatever the number is, her share of his base pay as a major at the date of service or at the date of decree, whatever that number is. So 29 of his retired pay. So if his retired pay would be 50%, then her.
So
Yes,
what
ma'am.
what cases say what the answer should be? Now that's a question of state law, right?
There isn't a case that says that. And partly it's because we had this change in the federal law that didn't exist previously. So it used to be that they got a piece of whatever the retirement benefit was, some number of months. And now it says, based upon his retired pay, what it would have been at the pay grade that he had at the date of the divorce. And that's under 20. I've cited that to you, yes. And I've given you a copy of the statute in my appendix too. So you can see that for yourself. And so this is different. But they do say that you can do other things. And when I look at that, given the complexity of doing something like this, to me, sometimes one spouse has a pension, their pensions are about equal, so they each keep their own. And maybe they're a little bit different, and somebody does a present value analysis so they can decide what's an approximately fair number. But part of the problem that you have in a case like this is that until husband retires, you don't know what his disposable retired pay is. That's part of the problem. And he could become disabled, for example. I mean, he's a pilot. He could have some serious injury. I mean, pilots have this. And having been one myself, I'm acutely aware of what the problems can be. And so I think that's part of the problem inherent in this. It's not like the DPS pension where, for example, or the public safety pensions where at 20 years they get 50% and it's based on their high 3 years, and so at that point in time you know what the number is. But in the federal system that's not so. There are 4 different things that get taken into account at the time of retirement, and among them is a survivor benefit. If he remarries, he can get a survivor benefit for another spouse, for example, if he chooses, and he's absolutely entitled to do that under federal law. But if the benefit were couched in terms of what his base pay was as a major at the time of divorce, plus cost of living increases from the date of retirement, and that's less than half of his ultimate benefit, then she would get that even if he did take a partial disability, if that ended up being half. And I mean, that's how I see that. And I think it makes sense logically to do things that way. And so, I mean, this is not my statute. This is Congress's statute. And I cited you a case in the opening brief where years ago the court had made a comment about, I think it was civil pensions, where it says part of the reason for these pensions is so that the federal government can attract and retain competent people to do their business. And therefore, these are uniquely federal matters. And I think that the statutes are clear enough, and I think under Howell, and I grant you that dealt with the disability. But the trial court here relied on Howell, the state decision, not the Supreme Court decision.
Well, that's, yeah.
Yeah.
You said, you made reference to the purchase of an annuity. Does the, as a survivor benefit?
Yes.
Is military retirement pay reduced by the purchase of an annuity for a current spouse that separate and apart from any court order?
It's reduced by the premium for that benefit. That's correct.
So is it your position that the pursuant to court order language in that sentence applies only to ex-spouse, not the current spouse?
The survivor benefit annuity to reach disposable retired pay applies to whatever survivor benefit annuity is taken at the time of retirement, period, no matter which spouse it's for. And so that reduces disposable retired pay. And I'll grant you, it at first blush sounds unfair, except that if you're basing the retired pay upon the base pay at the date of the decree, and where you're talking about here, you're only talking about 50-something% of the retired pay being community, I think would be a non-issue under that, because the premium, I think it's like 15% of retired pay for a 50 or 55% survivor benefit. And so that could come out of his share, and if you have a specific amount she's supposed to get, I don't think it would affect it in this case.
Well, what I'm speaking of is 1408A4.
Yes.
A4, which says that MRP does not include premiums deducted because of an election to provide an annuity to a spouse or former spouse to whom payment is being made pursuant to court order.
Mm-hmm.
So I read that as meaning it does not include the deduction for a premium paid for a survivor benefit to a former spouse to whom payment is made pursuant to court order.
I think it applies to any spouse to whom payment is made pursuant to a court order, so I don't think it applies in this case because there's no former marriage, and so there's no such thing.
Mr. Cook, you wouldn't need a court order if it was his current spouse.
That's correct.
So
you would.
It can only apply to a former spouse.
It can only apply, well, when he retires, if he's married, he can take out a survivor benefit for his current spouse, but I don't think, but that's not going to be somebody paid pursuant to a court order, at least not at this time. And
Well, that's Judge Johnson's question.
Yes.
Do we
Okay,
read
well,
pursuant to
then
a
I
court order
then I misunderstood.
relating to
Yeah.
a current spouse or a former spouse?
Yes, well,
it makes no sense if we read it to a current spouse.
Well, I think it doesn't matter because the survivor benefit here is less than 60%. I mean, the marital community's interest is less than 60% anyway. So to me, it would be a moot point because the survivor benefit premium isn't that high. So it doesn't matter. That's why I didn't spend any time looking at that particularly, other than to say that there are statutory things that are provided for. But there's no order dividing the pension in this case. I don't even think the court did one here, but all we have is a decree right yet. And
Well, you need to figure out what it's, after the appeal, what it needs to say, right?
That's correct, Your Honor. That's the problem.
As of the, okay, let's talk about the date issue. One, real quick, the form, box 66,
Yes.
says, as I read it, July 13th, 2003. Is that the right date?
Well, that's my understanding from my client. I think that's it. That's the day he started on the active duty for pay purposes.
Okay.
So 20 years from that date, theoretically, would be the earliest he could retire, but because he's an officer, he's subject to the discretion of the military, even if he wanted to retire. I mean, they don't always let you out. So, and doing so would probably foreclose his opportunities to become a general, for example, and have a much higher retirement benefit. And federal government would lose the services of somebody that paid more than $1 million to train. And so I think that's the reason we have to rely on the federal statute and apply it the way it's written by Congress. I would say with respect to the other arguments, as to argument 3, I think on the Bobrow case or whatever, no one has disputed that husband had paid more than $38,000 of his own separate money for marital expenses, pendenti lite. We withdrew our argument 4 because the evidence is murky, and we have an issue with respect to the trial court imposing its own limits on paralegal fees.
I'm curious about that issue.
So am I.
Well, I'm curious in the sense that it reduced her fee award, not yours. So why would you raise that?
I don't know, Your Honor. I don't think it did. And the reason is because I use my paralegals more than she does. And so if the court was going to balance how much we paid and how much she paid, the end result would have been less, not more. But
what did the court do here? I mean, how did it take into account your paralegal fees?
Well, it reduced all of them to $50 an hour, even though it's $175 per contract, and even though no court has ever told me that's too much. I mean,
and what did it do after it reduced those bills?
And then what it did was it compared who paid how much and ordered husband to pay half the difference.
So it reduced yours, didn't reduce hers so much because she didn't use so many paralegals?
Yes.
Or so many hours?
And so, but I think if you've had one spouse that has paid more, and I see what you're saying, Jed, but you have one that's had to pay so much for with respect to their fees and costs, it's not reasonable to say that that's an unreasonable charge. And I don't think it's reasonable for the court to be comparing paralegal fees or legal fees, whatever, to what a judge makes, with all due respect, because there are lots of expenses that go into the private practice of law that the court doesn't have. And so I'm not sure if you're correct or not about that. It's interesting to hear you say that. Hadn't looked at it that way, but nonetheless, I do think that it's appropriate. I don't think the court can say half the difference should be paid, because I think part of the problem that you have with his husband paid his fees largely with his own separate funds, and I don't see why what he paid relates to how much wife should be paid, other than the fact that I think when he's had to pay as much as he did, that there's an unfairness in having to pay her fees too, particularly when I think that some of these issues that we've had to raise on appeal, I don't think are reasonable. I would like to reserve the rest of my time, if I may.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. If it please the Court, Mary Boyd Henderson on behalf of Shelley Barron, appellee. I'd like to maybe start with the issue of the children, since that, as Mr. Cook has characterized it, is the most important issue, certainly to my client. As Your Honors are certainly well aware, this is an abuse of discretion question. So what Your Honor would have to determine in order to set aside or modify the court's order is that the judge somehow abused its discretion.
Does the court abuse its discretion when it considers things that he shouldn't consider, or or doesn't consider things that they should consider?
I certainly think that that would make an abuse of discretion possible, but not automatic. And I am assuming Your Honor is referring to the comment that the judge made in his findings with regard to the children being girls and perhaps needing to spend more time with mother. I would have.
How about the comment where he says that children should stay in one location and not, or basically saying that the one I found somewhat offensive was the timeshare reference.
That children are not timeshares?
Not timeshares, and so we shouldn't give them equal time.
That's actually a line that I've seen in some, I want to say I saw it in a published opinion recently, but I can't cite the court to that, so I can't be certain. But it is something that this particular judge, if you know him, says a lot. And I've always interpreted that to mean that we don't treat children as property, that we don't treat the parents' rights to their children without looking at the children's best interests. So when you have a timeshare, for example, the presumption would be that it can be shared between parties without any harm to the timeshare. When we treat children in that way, however, there are consequences to that. And the consequences can include a lack of adjustment. There's lots of research on adjustment disorder associated with placing children in certain timeshare arrangements that don't consider their best interests. So
none of that evidence was presented in this case. There's no evidence that the children were going to do better. There's no expert evidence that the children are going to do better if they were primarily resided with one parent over the other. Is there?
There was certainly no expert evidence presented at trial. However, there was a lot of testimony about the parenting plan that had existed in place by agreement following temporary orders, and how these children had functioned under that agreement, and the problems that they had had. And the problems were acknowledged not only by mother, but by father as well. And because of those problems, my interpretation of that comment that the court made was that I can't just walk into this and assume children should spend exactly equal time with both parents without looking at the effect that that's going to have on the children. Be that through expert testimony, or be that through the testimony of these particular children. For example, one of the children was attending counseling and had actually asked to attend counseling because she was having problems adjusting to the plan. And that was only one of the various findings that the court made. And I can see where that could be interpreted in an offensive manner. I don't think it was intended by the court in that manner.
What about the gender issue? Because even when it was pointed out to him that, you can't do that, he didn't disavow that I won't do that. He just said, well, I'm not going to give it much weight.
Well, what the statute says is that the court cannot award custody based on gender. And I don't think that that's what this court did. I think that if you took that gender comment completely out of the court's findings and ignored it entirely, the remainder of the findings support the orders that the court made. I think that he was simply acknowledging, and perhaps he should have done this, perhaps he shouldn't have. I will leave that to you all to look at. But he was simply acknowledging that it was likely that these girls may want to spend more time with their mother, as they had expressed up to that time. And he did make the comment that in part that was based on the fact that they were girls and mother was a girl. But the record reflects that the girls had already expressed that same request. They had been expressing regularly and repeatedly a desire to spend more time with mom, regularly and repeatedly that there was issues where they felt like they were being parented by their grandparents in father's home because father was out of the home so much.
That's a different issue.
True, but it is part of the same findings that support the court's orders.
What about the notion that he said he didn't think equal time was appropriate because kids needed to have a central home where all their favorite things are? Wouldn't that isn't that a rule that would effectively rule out equal parenting time situations?
I suppose it would depend on how it was applied. Again, I interpreted that line in the context of these facts to be a reference to the fact that father's military career had, in fact, moved him all over the country. Now that the parties are not together, if and when father's next assignment takes him away, there is no obligation on the part of mother to move. And that at that point, there's going to have to be a decision and discussion about where the children's best interests are going to lie. And I think the trial court anticipated that is going to be a problem and that the children's interests would be served.
Well, and that raises another interesting issue. Is there are some other issues about the trial judge's anticipation of what may happen in the future. But isn't that pure speculation on his part?
I don't think so. I mean, the record in this case reflected that these parties had moved repeatedly and that they had never spent more than 5 years in one location. As I remember, there was testimony that father was going to likely be called up for another assignment within 2 to 3 years, as I remember, from the time of the trial. So this was something that was anticipated. Counsel asked my client, mother, specifically whether isn't it true that you knew that this was something that was going to happen because you married a Marine? She testified she knew that was going to happen. Father testified he knew that was going to happen. It's part of military life.
Don't the statutes anticipate that may happen and specifically allow for moving out of state? So, I mean, don't you decide the case based on the facts presented at the time of dissolution and worry about change in circumstance later when it happens?
I think generally I would agree with you. However, the facts of the case are that father is a military member and that there are certain obligations associated with that. What the statutes that we have deal with would be a situation where father wanted to take the children with him outside of the state. So in other words, father's free to go. If the military assigns him somewhere, he's free to go. The question before the court in a relocation case would be whether he's entitled to take the children.
Or he could, at that point in time, he would file a petition under 411 and ask for a change in parenting plan based on the fact that he's moving out of state and now needs to do a long-distance parenting plan. But under either scenario, we don't anticipate what's going to happen. We deal with the situation at the time of dissolution.
Again, I generally agree with you. I think that both parties went into trial and both parties testified to the judge that it was expected and likely that this change in his military service was going to occur. And I think that is what was presented to the court, and the court relied on that evidence.
I've got a question about military retirement pay. The same
Yes.
question that I gave to your colleague. If we conclude under Howell that an Arizona state court may not require a military spouse to indemnify the non-military spouse in the event that he chooses not to retire at 20 years. What should the order say about the formula to be awarded to the non-military spouse at the time of retirement? Is the denominator 20 years, or is the denominator the number of years of service that it eventually has accrued?
I think that father is attempting to, in his argument, suggest that the calculation of mother's interest itself be altered to consider all of his military service if he works beyond 20 years. I think that's what your question is addressed to. This would obviously prejudice mother further. So in other words, if mother is already prejudiced because she can't receive retired pay at the time that father could have retired, and also the total length of father's service for the calculation is expanded, it reduces mother's percentage of the overall benefit. So it not only would mean that mother would have lost out on the payments that were waived in favor of continuing service, it would also result in a lower percentage awarded to wife.
Possibly a higher number.
Possibly, I think.
That's a suggestion.
I think that came up this morning, and I heard that, but I would check the federal statute 1408 because I believe that there's a calculation, the calculation of mother's benefit, as I recall from that statute, is limited to rank and pay at the time of the dissolution decree. So if it's limited to rank and pay at the time of the dissolution decree, then the total benefit under that calculation would not increase. Mother's percentage would simply decrease.
And you think that's in 1408?
Yes.
Okay.
Counsel, earlier you had said the statute prohibits any sort of final decision based on gender, does it contemplate that you can account for gender, or it just can't be the determining factor?
I confess I'm going to probably answer this question more from personal feeling than from established case law, because I don't know that there's an established case that discusses this particularly. I think that it is the judge's primary job under statute to consider the best interests of the children. If the best interests of the children are impacted in some way by gender, then I think it's appropriate for the court to consider that particular impact. It is not appropriate, it is not constitutional for a court to say, Mom, your mother, you get the children. It is perhaps constitutional and correct for a court to say, these particular children need this particular parent because of some gender issue, and that consider that in the overall award.
When would that ever come to being? I mean, we just consider what the children need based on what particular parent we're talking about, regardless of gender, right?
That is, I think in 99.9% of situations, I think you're exactly right. The one situation I'm sort of perhaps thinking of as I answer this question would be a situation where a child was considering was facing issues associated with potential gender reassignment, and one of the parents may have undergone that kind of issue in their own lives, and that child may need to spend more time with that parent in order to understand that.
But we don't talk about gender. We just say parent A is clearly in a better position to relate to the child. But to say, oh, the child needs to go with his mother or her mother because she's the mother, as you just said, is inappropriate.
Well, I'm not sure I would have included the comment that the judge made when he made his findings. If I had written that opinion, I would have not included that. I would have not considered that as an issue.
But he didn't back down when it was pointed out to him.
I understand. But I do think that what we're here to do today is determine overall whether the judge abused his discretion. And I think,
as I see, that was inappropriate.
I wouldn't have done it. I don't think I'm here to say that judges are appropriate or inappropriate. I'm not going to make those judgments. But if I were drafting that opinion, I would not have included it.
I guess for me, and I don't mean to monopolize the time here, but if we're talking about weighing and balancing and you put an illegal thumb on one side of the scale, how can we say, oh, that's not an abuse of discretion?
Well, I think you take it out. I think you take it out completely, as I've argued.
Aren't we re-weighing?
I don't think so. I think the court himself said that he gave virtually no weight to that consideration. I mean, he didn't back down from it, as Your Honor noted, but he also said he gave it virtually no weight. When a trial court says that, then I think you have to...
Well, the inverse of that is he gave it some weight.
Perhaps.
I do have a question. Do you have any more military pay? Because that's obviously more important.
I'm done with military pay. I would like to know about paralegals.
That's what I was going to ask.
So what's up with the paralegals?
I don't know. I know that when the attorney's fees were submitted to the court, father's attorney's fees were much higher. The paralegal costs on father's side were much higher. Paralegals had been used more often, and the billable rate for paralegals was higher. I view this order as a tool that the judge tried to use to reach an equitable finding. In other words, the record is clear that the court considered 25-324, considered the reasonableness of the parties, considered the amount of attorney's fees, and the ability to pay those fees. I view this as a tool that the court used to try to explain and get to a figure that the court felt was equitable. I would analogize this to the old Maricopa County spousal maintenance guidelines, which I have never favored and hated when they existed. But the case law that discussed those issues concluded that, look, the court can do one of these calculations. The court can come up with a number based on these guidelines. But unless the court is relying solely on the guidelines and not considering the statute, it's not an abuse of discretion. And so I think that that's what's happened here. the court clearly considered the reasonableness of the parties, clearly considered the ability to pay the fees. The court came up with a means of reaching a number that the court thought was a fair distribution of those fees between the parties.
Did he actually do what Mr. Cook said, is that he took the fees that father had and then the fees that you submitted and just half the difference between them?
Well, he didn't half the difference. What he did was he basically said, okay, both parties make a certain percentage of the total income, sort of like we do in the child support guidelines. And then these are the reasonable fees for father, these are the reasonable fees for mother, and took the difference and suggested that father should pay his the percentage of the difference that was his percentage of the total income. So it wasn't exactly half as I remember it. So I think that this was, like I said, I think it was a tool to get to a number that the court felt was reasonable. I don't think he did that in place and stead of consideration of 25,324.
Did it disadvantage your client to have him discount your paralegal's fees?
The elimination of the paralegal fees probably slightly favored my client, applying the rest of the court's methodology, right? So I think the paralegal fees, as I indicated for Mr. Cook, were higher. There was more paralegal time, and the time was billed at a higher rate. So there was certainly more paralegal time eliminated from husband's fees than were eliminated from wife's fees. So I think that as the court applied the rest of its analysis, because husband's fees were reduced.
So I'm having a hard time with this. So he reduced both sides' fees
Yes.
because of paralegals.
Yes.
And then what did the court do, so far as you know?
And then it added those together and divided them out based on as we would do, similar to the way we would do in a child support worksheet. So divided them out according to the percentage of income that earned by each party.
Oh, okay.
Counselor, I want to go back to your argument that if a court makes a decision and one of the grounds was improper or illegal, had no basis in the law, that what we're supposed to do is just take that off and then look at it. Do you have any authority, any case law?
I don't have that with me, Your Honor. I'm relying on the general abuse of discretion standard, and I think that if there's evidence in the record to support the court's decision, then this decision should stand. That's our argument.
And does it matter how improper the factor was, or did you just strip it off, regardless of what it is, and assess?
I think you're asking me a general question that's harder to answer than the specific question. So in this case, the trial court, as has been noted, was made aware of the factor. And although the court didn't back off the factor, the court did make a finding that it gave that factor virtually no weight. Some weight, but virtually no weight. And so I think that it would be the place of this court to say, okay, if the court gave it virtually no weight, then how did that factor affect the rest of the calculation the court made? And I think it doesn't. I think the court said that when it was brought to the court's attention, that I would have found the same way, but regardless of this.
And I hate to make you keep jumping around, but
Okay.
I really do want to clarify this paralegal thing. You practice in Yuma. Mr. Cook primarily practices in Phoenix.
Yes, Your Honor.
Is there a difference in paralegal rates? I mean, and you can tell me, but is it in the record? Is more what I'm.
The difference between counties is certainly not in the record. There was no evidence presented regarding standard of fees in Maricopa County. This particular judge.
Or standard of fees in Yuma.
Or standard of fees in Yuma. I think this particular judge would have been aware, have some awareness of it in that he used to be a private practitioner, so he would have some awareness of fees, at least in the Yuma County area. But there was not a record before the court with regard to what the different standards were in the different counties.
Thanks.
Thank you.
Thank you, Your Honor. I'll try to address the things that were raised that I had issues with. The gender issue. Now, there's nothing in the record to indicate the father is insensitive to his daughter's gender records. Nothing in the record to indicate that at all. And you're correct, Your Honor. There were no expert testimony in anything. The only unbiased testimony in the record about how the kids were doing are the school records, which indicate improvement in their deportment in school, their habits and everything else, as well as their grades from early in 2016 until up through October of 2016. So that record is one of the appendices to my brief. You asked if the court abuses discretion by failing to consider something that's supposed to or considering something that's not supposed to. And I think there can be an abuse of discretion in either direction, Your Honor. I don't think it's an abuse of discretion to consider something that's not a statutory requirement. You're certainly allowed to go outside that, but it has to be something that's reasonable, that has to do with the welfare of the children and the relationships between the parents and others, not just gender, for example. And I agree that children aren't timeshares, but I took the comment the way maybe the court did, because I think they need both parents. I think our statutory presumptions are that they need both parents. And this court went from the temporary plan that was stipulated and agreed upon and only in place for about 6 months, where father had 6 out of 14 nights, taking him down to 4 out of 14 nights. And there's nothing in the record to indicate that he's the person being unreasonable here. I don't think you can be unreasonable if you're relying on a temporary order. Some of the things that counsel commented about, child attending counsel or wanting weekends, this happened over the summer. Every day is a weekend. Monday through Sunday, they're all weekends because it's over the summer. And you have to wonder, where's the child say, I want weekends, when every day's a weekend? You might infer reasonably that that came from a parent. So, there was an offer made by Major Barron about retirement, and they didn't accept that, so here we find ourselves. Last thing with respect to fees. If the court thinks that these issues that I've raised with the court on behalf of Major Barron are reasonable issues to raise, then I'd like to know what the unreasonableness is that father did. Father had to submit his pretrial statement beforehand because mother wouldn't provide one, even though she was the petitioner. And they both went to trial thinking they were both asking for 50-50 parenting time, and then this happened. And so I think we've cited the court to the cases. It's not just the gender. It's not just the comment about girls should be with their mother. There's much more to it than that, and I agree with the implication of the question asked by Your Honor that you're not in a position to reweigh all this, and I don't think you should have to. Thank you.
Thank you. Thank you to both lawyers for your briefs and your argument. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.
Thank you.